Well, hello, everyone, and thank you so much for joining us tonight on a very important topic and very timely topic. We are about to enter the 2024 elections. You know, the other day, the New York Times had this headline that I think everyone should at least try to see. Let me see if I can pull it up. If I can't, that's okay. The headline from the New York Times was, "The 2024 election will be unlike any other. Is the media ready?" And here at SPJ New England and SPJ in general, we wanted to answer that question by saying, yes, we can prepare the media to be ready when it comes to the First Amendment and understanding the free speech rights and the free press rights of those that are covering the 2024 election. And what better person to be with us and to explain just the beauty of the First Amendment and what does it mean to be a defender of a free press and free speech than to have Nadine Strossen, who, my goodness, I am a huge fan. When I was a rookie reporter, in the 90s, coming up through the ranks, she was already a big deal. Doing the work of defending the First Amendment as president of the ACLU. And Nadine, I mean, I could probably spend the next hour just touting the amazing work you've done when it comes to a free press and free speech. But what is the elevator pitch that you tell people when they ask you, well, so what do you do for a living?
I am a full-time crusader for free speech. And Izzy, first of all, thank you and thank this very important organization for hosting the webinar. I am so indebted to journalists. You, as you know, have been called the fourth branch of government in effect, because you are the watchdog that is an essential check and balance over the other branches and units of government. I have been a full-time crusader for the full range of civil liberties and human rights throughout my adult career. But starting about 10 years ago, Izzy, I started to see attacks from both ends of the political spectrum on fundamental free speech principles. People were starting to criticize freedom of speech, to attack it, to say that it goes too far. And I felt that there was nothing more important I could do with my time than to explain why the First Amendment is so important. So that's my pitch about what I have been doing. Now, if you want me to give the substantive pitch as to why it's so important, I can segue into that.
Well, we thought, how much time do we leave to why the importance of the First Amendment? Certainly over the next hour, I think we're going to cover that. But there was one online publication who called you a card-carrying defender of free speech, and I guess by extension that also applies to a free press. So the fact that you are such a passionate defender of the First Amendment at this point in time, put it into context as we come to another election. And we start talking about things like democracy and individual rights and a free press. What does it mean to you as someone who's done this work all her life?
That freedom of speech and freedom of the press, which really are coextensive. The United States Supreme Court has defined both of those rights in the same way. So the press does not have special rights above and beyond those that are exercised by ordinary individuals. But the press as an institution has played historically a special role in informing all of us. And what is so essential in a democracy, Izzy, is not only freedom to convey information and ideas, but also freedom to receive information and ideas. We cannot exercise our sovereign power, we the people, to quote the opening words in the Constitution, unless we have full access to information about those who seek to represent us, those who are running for office, those who hold office. And we also have to have the most robust rights to be able to question them and criticize them and dissent from their policies. That is democracy in action. So the United States Supreme Court has said that when it comes to speech about matters of public affairs, we are talking not only about individual liberty, we are talking about the essence of self-government.
You have written several books. One of them, it's a must-read in my classroom. The title of the book is Hate: Why We Should Resist It with Free Speech, Not Censorship. But you recently wrote a new book, Free Speech: What Everyone Needs to Know. And you just released this book late in 2023. I think it's a book that all journalists should really get so they can understand the work that they are doing. But before we dive deep into what the book talks about and how we can help journalists as they pursue coverage that is rigorous when it comes to 2024 election, I noticed that you dedicated the book to Salman Rushdie. Tell us, a lot of people know who he is, but tell us why you wanted to dedicate this book to the amazing work that this precious person has done throughout his life.
He has shown unparalleled courage in standing up for not only his own free speech rights, but also the free speech rights of embattled writers and others all over the world. People know probably that since 1989, he has been subject to a fatwa, a religious edict, putting a bounty on his head by the former supreme leader of Iran. More recently, just a couple of years ago, when he was going to be giving a speech at the Chautauqua Institution, ironically, a speech in which he was talking about how America has provided a special haven for controversial writers who are persecuted in other countries. He was physically assaulted and attacked, and thank goodness has survived, but with life-impairing, life-altering injuries. He's lost the sight of one eye. He's lost the use of one hand, which is a great impairment to a writer, and yet he continues not only to write eloquent, beautiful, inspiring books, but also to be an advocate for free speech, especially for writers and journalists. He's been very active with an organization called PEN, which is an organization of writers and journalists that defends free speech, especially for those professions. He's been a past national president of PEN, and he's been so consistent when even other writers start to suggest that we should perhaps not defend freedom for speech that is critical or that might be offensive to certain groups. Rushdie has been consistent in standing for free speech. Let me give one example. After the bombing attacks on Charlie Hebdo in Paris, PEN was going to give its annual award to Charlie Hebdo, and that led to a petition by many writers who were members of PEN saying, no, Charlie Hebdo should not be honored because it's not an appropriate use of free speech to make fun of Islam, which Charlie Hebdo allegedly had done. And they used the concept of you're punching down and you should not be able to punch down. Rushdie wrote just an amazing, remarkable letter about how this freedom is absolutely critical. The right to mock all religions, including Islam, the right to engage in satire, and whether you're punching up or punching down, that this is essential to not only literature, but also to liberty and to our democratic society. And I could just go on and on about his constant heroism, despite having paid a very heavy price personally.
And it's important to note that PEN America has been one of the leading voices when it comes to defending journalists around the world, whether it is that they are attacked by a local government or they are in prison. PEN America is a strong defender of those who write for a living. Speaking of that, Nadine, I know you are an amazing scholar when it comes to the First Amendment, but you're also an educator. And you wrote this in your book. You said education about free speech and the press tends to promote its protection in two ways. What are those ways? So for the people who are watching, so that they know, what does it mean to be a defender of the First Amendment?
Well, first of all, I have always separated my roles as educator from my role as advocate. When I was president of the ACLU, many people don't know that's a volunteer position. I was earning my living as a law professor at New York Law School. And as a law professor, I believe that my responsibility is never to indoctrinate my students. It's to open their minds, to spur critical inquiry, to expose them to multiple perspectives. As an advocate, though, I am advocating a particularly strong interpretation of the First Amendment. But what I found, Izzy, is that there's an overlap. The more people understand about what First Amendment principles actually are, the more they understand that these principles accord with common sense, and the more they understand about the history that gave rise to our current strong speech protective principles and the terrible experience that we had with censorship before that, even well-intended censorship, the more supportive they tend to become. A lot of people who attack the First Amendment, which has become quite fashionable, are actually attacking a caricatured, demonized version that bears no relationship to the reality. I can't tell you how often I have been accused of being a free speech absolutist. And oh, you free speech absolutists deny that speech ever causes any harm, and you say that speech should never be subject to any limits at all. And the United States is so ridiculously extreme. It's an exceptionalist in the world in strongly protecting free speech. All of those generalizations and stereotypes are completely inaccurate. The more you know about free speech, and I hope my book makes this clear, the more it becomes evident that our system of law, our First Amendment principles, do empower government to outlaw the speech that is the most dangerous, but those principles also bar government from engaging in the censorship that is the most dangerous. So what do I mean by that? The censorship that is the most dangerous is what the Supreme Court calls the viewpoint neutrality principle. When government engages in viewpoint discrimination, suppressing speech only because of disagreement with or disfavor or general fear of the viewpoint, the idea, the content, or the message, that is the most dangerous form of censorship, because we, the people, are the ones who should make decisions about which ideas deserve our support and which ideas should be rejected. It's not for the government to take those decisions away from us. However, when you get beyond the content, the message, the idea of the speech, and you look at the speech in its overall context, if in particular facts and circumstances, the speech directly causes or threatens certain specific imminent serious harm, then it can and should be punished.
You know, you're talking about people understanding these issues that we're talking about, when the government can step in, when they can't, when they can regulate. You write in the book this, you say that government offices should be held accountable for wanting to get away with violating the First Amendment. But you say, in order for journalists, for reporters, for citizens to be aware of such violations, they must know what their rights are. I've read some studies that ask questions of reporters when it comes to the First Amendment, and sometimes they don't know also these boundaries of what it means to be a First Amendment defender. And certainly reporters should be the ones that are leading the way.
And Izzy, certainly one of the audiences that I had in mind when I wrote my book was journalists, because I'm regularly doing interviews with the media and journalists who are very, that I respect a lot and are quite experienced, lack basic information about First Amendment principles. And I don't say this critically, because they obviously weren't given an opportunity to learn those principles. And I very much appreciate the opportunity. They call me up and I give them a crash course, a tutorial, right? But I thought I might as well, rather than constantly doing this orally one by one, I might as well include the answers. And by the way, the book is in question and answer format. So I think it's a very handy reference for journalists. But I don't mean to single out journalists play an incredibly important role, as we've been talking about, but so do lawyers. And Izzy, there are a lot of lawyers that are woefully ignorant about First Amendment principles. Many law schools now do not require the First Amendment as a program of study. You can graduate from law school without having spent 1 hour studying the First Amendment. And so, there are regularly statements by politicians, by government officials who are law school graduates, who will say things such as, hate speech isn't free speech. And that is legally incorrect. So everybody can profit from more knowledge, including members of my own profession.
You wrote this in your book, and again, it's an amazing book, and that's why I'm pulling quotes, because I want reporters to read this book. But you said, if you're quoting George Orwell, and you say, if large numbers of people believe in freedom of speech, there will be freedom of speech, even if the law forbids it. But if public opinion is sluggish, inconvenient, minorities will be prosecuted, even if the laws exist to protect them. And when I read that quote, Nadine, I remember a few days ago, The Fire, which is an organization, you're a senior fellow at The Fire, which is its responsibilities to defend the First Amendment beyond education. They put out a poll. They released the data. They said that nearly 1/3 of Americans, GOP and Democrats on all sides, say the First Amendment goes too far in the rights that it guarantees. More than half agree that their local community should not allow a public speech that espouses a belief they find particularly offensive. I remember as a journalist, when I was working in local markets, whether it was El Paso, Texas, Charlotte, North Carolina, or West Palm Beach, as a reporter, I'd have to sometimes report on these issues. And I found that it was my responsibility to explain the First Amendment so that the public would know that while you may want to cancel this kind of speech, the First Amendment protects it.
And all of us have a stake in that viewpoint neutrality, right? That comes back to that core principle I referred to earlier, which, by the way, the Supreme Court has called the bedrock principle of our whole system of First Amendment law, that we have the right to be offended, but we don't have the right not to be offended. We also have the right to say things that will offend other people. And given the wonderful diversity of this country, Izzy, no two people can possibly agree on what is offensive, what is insulting, what is hate speech, what's extremist speech. And I've seen so many examples where, the very same expression in one community is going to be very popular and cherished, and in another community is going to be seen as very dangerous and subject to suppression. I think the most famous or infamous, depending on your perspective, case that upheld this viewpoint neutrality principle was an ACLU case from the late 1970s, the so-called Skokie case, where the ACLU came to the defense of a group of neo-Nazis who were peacefully demonstrating in Skokie, Illinois, a city near Chicago that had a large Jewish population, many of whom were Holocaust survivors. And it was an easy case in the courts of law because the mere fact that their Nazis' viewpoint was loathsome and subject to being, we revile that viewpoint, but that's not a justification for government censorship. It is a justification for answering it back, refuting it, ignoring it, doing whatever you can to de-amplify the message. At the a few years before the Skokie case, the ACLU also came to the defense of the viewpoint neutrality principle for speech very nearby, but which had an diametrically opposite message. This speech was in Cicero, Illinois, with a very different demographic. It was very conservative, a lot of people who were very hostile to civil rights. A Time magazine story described Cicero, Illinois as Selma, Alabama, without the Southern accent. And it was Martin Luther King who wanted to demonstrate in Cicero, Illinois, and his speech was attacked as hateful and dangerous and extremist. So it was the very same viewpoint neutrality principle came to the defense of both the Nazis in Skokie and the anti-Nazis, pro-civil rights demonstrators in Cicero.
I imagine in 2024, a lot of the work that journalists are going to be doing will be covering these protests throughout the country, California, Texas, Florida. This will be part of the story. And in chapter 2 of your book, the title of the chapter is called "The Most Important Arguments for and Against Free Speech." I love that you bring out the nuance of the First Amendment. And you mentioned Skokie, you mentioned the ACLU defended Nazis marching through downtown Skokie, but you also distinguish that with what happened with Charlottesville and how you have taken the position that, look, what happened in Charlottesville, it's much different because of this area where we are talking about danger that is imminent. Can you talk about that? Because I can imagine that reporters will find themselves in something similar. Whether it's
Absolutely.
Skokie, right? Skokie-esque or Charlottesville-esque.
Yeah, yes. The Charlottesville situation actually illustrates both the viewpoint neutrality principle and the other principle, which is often called the emergency principle, that when the speech in context presents an imminent danger or directly causes specific harm. And both of those situations were evident in Charlottesville. The Unite the Right demonstrators were marching with vile chants. "You will not replace us. Jews will not replace us." Loathsome and repugnant as those messages are, that is not enough to justify censoring them, right? It's enough to justify counter speech, counter protests, which did occur. Or if you think it's a more useful strategy, perhaps ignoring them, not giving them the oxygen and the attention that they seek. However, what happened on the Friday night before the planned march, everybody will recall, was that these protesters were not only chanting those vile messages, they were doing so while marching en masse toward a group of counter demonstrators who were ringing the Thomas Jefferson statue on the University of Virginia campus at menacingly close distance, and not only chanting those epithets, but also brandishing lighted tiki torches. That kind of expression, when you consider the overall context, clearly crosses the line. In fact, it satisfies one of the multiple subcategories that the Supreme Court has recognized for speech that does pose an emergency. And this particular category is called a true threat. And the courts use that adjective true to distinguish it from the looser way we use the word threat in everyday speech. But to be a punishable true threat, the speaker has to be targeting, directly addressing an individual or a small group of individuals, and the speaker has to either intentionally or recklessly instill a reasonable fear on the part of the targeted audience member that they will be subject to violence. And note that the speaker doesn't have to intend to actually carry out the violence. The harm is done solely when the targeted audience member reasonably fears violence, because if you reasonably fear that you're going to be attacked, that means an objective fear, not just a subjective one, that's going to curtail your freedom of speech and your freedom of movement. And one of the tragedies in the Charlottesville situation was when the expression crossed the line and should have been punished, it wasn't subject to punishment. Indeed, as we know, actual violent actions, namely mowing down pedestrians with a car, was not prevented. There was not a sufficient police presence there.
And with that in mind, we've already seen this not just in the public arena, but also in college campuses. This idea that protesters show up and they try to shut down a speech. It could be a speech by a politician, it could be a speech by a professor, it could be a speech by someone who does the work of policy and politics. Can you describe, because you answer this question in chapter 2 when you say, doesn't the First Amendment law wrongly privileges freedom of speech above equality rights? And you distinguish between the rights of the speakers, the right of the listeners, and the right of those who want to protest when they cross the line between protest and then action that stifles the speech of others.
Exactly. So the right to peaceful, non-disruptive protest is very important. It is essential for propelling law reform throughout American history. Protests have led to constitutional amendments and to major developments that have promoted human rights, including women's suffrage, abolition of slavery, the civil rights movement, the women's rights movement, anti-war movements. So many causes have depended on the right of peaceful protest. If, however, and by the way, the First Amendment itself, and I have to show you my First Amendment mug here, has the exact language of the First Amendment.
Nice.
And many people don't recall, Izzy, that the right of assembly expressly is the right of the people peaceably to assemble, right? So the adjective peaceably is right there in the First Amendment. If you are engaging in violent or disruptive forms of assembly or protest, that is not protected by the First Amendment. And to the contrary, it interferes with the First Amendment rights of others. So counter demonstrators have the right to briefly, or first of all, to silently express their disagreement with a speaker by holding up signs or by wearing armbands or by turning their backs or by walking out of the audience. There are many ways that they can convey their disagreement without uttering a sound and therefore not interfering with the right of the speaker to convey ideas and the right of the audience member to hear ideas. I also would defend the right of protesters to briefly heckle and boo, but they may not do so in such a sustained and prolonged and noisy fashion that they basically completely end the event or substantially interfere with the event.
To that end, and again, because I've been a journalist, I know what's happened during election years. I know protests are very important. In 2020, for example, we saw a lot of people take to the streets because they were fighting for civil rights. And journalists got caught in the middle at times. Sometimes they got caught between, two sides of a protest. Other times they were caught with the police, either not allowing them to be in a certain place or even arresting reporters. So to that end, what should reporters know when covering protest and this idea that they're there to cover the event, and yet the governments can't forbid them from reporting on matters of public importance?
Unfortunately, Izzy, the fact that we have a right doesn't necessarily mean that the right is going to be respected and enforced. A big part of what free speech organizations such as the ACLU and PEN and FIRE, to mention a few we've already alluded to, a huge percentage of our work is simply enforcing tried and true First Amendment principles that are honored in the breach by law enforcement officials who either are ignorant of what the law is, or in some cases will willfully violate the law. So it's absolute, and for example, there was a recent situation, all too typical, at Berkeley just within the last few days, where police said and security officials said that they could not arrest protesters who counter demonstrators who were shouting disruptively and making it impossible for a speaker to be heard and for audience members to hear the speaker, because they said, well, that's interfering with the free speech rights of the protesters. As I've just explained, no, they don't have a right to engage in disruptive protests, but sometimes the error is made in the other direction, when there is a right to engage in non-disruptive protest, and nonetheless, people are being arrested. The ACLU has had so many cases throughout our more than 100-year history of coming to the defense of people who were arrested and imprisoned for exercising classic First Amendment rights. So including journalists and including lawyers who are, and others who are monitors who are in place precisely to try to enforce First Amendment rights. So knowledge of your rights is absolutely critical. The willingness and ability to articulate what those rights are to law enforcement officers, hopefully to do so in a civil and polite and respectful and courteous way, and hopefully that will do the trick. But if not, contact the ACLU or FIRE or another organization that will be able to defend your rights.
And certainly 2020, one of the reasons why we had those protests was because an individual citizen recorded the actions of police when they were arresting George Floyd. We later found out that they were also guilty of murder in that case. And the ACLU, in accordance also with Reporters Committee for Freedom of the Press, they've been very forceful in saying that the recording of police officers and the actions is protected under the First Amendment. And that should be something that I guess this year, that's another thing that reporters should be aware of. What are the rights when it comes to doing that work of recording police in action?
I continue to be shocked when I keep seeing incidents of individual police officers wrongly asserting that there's no right to film them or photograph them, and they'll make statements about, oh, well, we're protecting the privacy of the person that we're arresting. Absolutely untrue. To the best of my knowledge, every single lawsuit that's been brought all over the country in federal and state courts all over the country, the courts have consistently upheld this critically important First Amendment right to document the work of public officials, including police officers. And by the way, I have been quite critical of specific police officers, so I want to say that, the vast majority of them are doing wonderful work, just the way the vast majority of journalists are doing wonderful work.
You mentioned that police officers often say, well, we're trying to protect the privacy of individuals. And it strikes me that that's also the same thing that we've heard from college campuses when we see student journalists trying to report on matters that are happening on campus. And forgive me, there's a train that's going through campus. As you know, Nadine, you've been here, and we have a train tracks right on the edge. So that's what you're hearing. But tell us a little bit about, especially the FIRE. The FIRE has been, I would say, on the cutting edge of protecting the work that's being done by student journalists on college campuses. But it is the position of SPJ National that a student journalist is just as protected as a professional journalist. So can you talk about the fact that there are also school administrators that try to prevent student journalists from covering some of these events where it's student groups, they're meeting, it could be student groups on one side or the
Yeah.
other. They're prevented, those students are prevented from doing the work of reporting on what's going on.
Right. And I should say, Izzy, by the way, maybe not everybody knows that FIRE is the acronym that now stands for the Foundation for Individual Rights and Expression. Until 2 years ago, for the first 20 or so years of its existence, the acronym stood for the Foundation for Individual Rights in Education. But given the proliferation of free speech problems in our society generally, FIRE decided to expand its mission beyond campus, but it still does a tremendous amount of work on campus. And let me also salute the Student Press Law Center, which does great work in defending high school student journalists, which are also who are also often subject to suppression by school officials. I was recently on a campus, I'm not going to mention which one it was, where this exact problem occurred, that the student newspaper was being denied access to important meetings of the Student Government Association, which is, representing the students, carrying out important policies, debating important policies, supposedly on behalf of the student body, and yet they were trying to suppress any press coverage. This is, the checking function that I mentioned at the beginning of our interview, where the press is a watchdog over those we elect to represent us and to do our business. We cannot hold them accountable if we don't have basic information about them. And this is one of the reasons why it's so tragic that the local press has been disappearing all over the country. Study after study shows that when there is no longer a local newspaper or a local TV station, taxes go up and corruption goes up. When there isn't the sunshine being the best disinfectant, then there is infection.
Let me stick with this point for just a minute, because this is very profound, and this is certainly an area that I'm very concerned about. And I'd love to get your take on this. But certainly we are seeing more and more local news coverage disappear. And it's national coverage. It's organizations that are not covering local governments, school boards, county commission meetings. As someone who's been doing this work all her life, how do you see this idea that the press is under attack? I know when I was at SPJ National and I was serving as the chair of the Legal Defense Fund, we had the situation where a newsroom in Kansas in a small town was raided by a police department because they were trying to cover local politics. And certainly we were very vocal about defending that. But that happens a lot more now, Nadine, than I can remember. And I'm curious if you're seeing the same thing.
I assume that there have been attempts to document whether there is actually an increase in these kinds of episodes. Even one is extremely disturbing. I'm not aware of, data on that point, Izzy, but what I am aware of is very troubling data about the negative attitudes on the part of politicians from both major political parties and of the public toward the media, that the media has really fallen in the public's estimation. It is distrusted, and that, a healthy amount of skepticism is a very good thing. It's essential in a democracy. We should have a healthy skepticism toward everybody who wields power, including those in the press. But when the distrust is so great that one dismisses everything that is written or published in the media, that is also extremely dangerous for democracy. If we don't trust the information, on what basis are we going to make decisions about public policies and about public officials. Donald Trump, when he was president, used the term, I think he started coining the term fake news. That said, the term disinformation has been slung about by President Biden and by many on the Democratic side of the aisle. So even though they're using different terminology, I think there is still a tendency on the part of both political parties to exaggerate the extent to which the media should not be believed, should be distrusted. And that's very corrosive.
Staying on this topic, and I'm glad you brought up this issue of misinformation and disinformation and now malformation. I wonder if we could talk about this issue, because, when I talk to journalists who are doing work out there and they say, well, shouldn't the government be able to do something about misinformation? And I tell people, I say, look, the Supreme Court has said that even lies are protected by the First Amendment. And they're like, wait, what do you mean? I was at UNC Chapel Hill just this weekend, and I was at a talk at a conference. It was a Latino conference, a Latin conference. And my talk was about election 2024 and the targeting of the Latino community when it comes to misinformation and disinformation, and how to prevent that. But can you talk about, we do have a concern, obviously everyone's talking about it, and reporters are going to be out there making sure and doing fact checking, but can you talk about why it is that when it comes to misinformation and disinformation, the government doesn't have a role in telling us what is misinformation and disinformation? And by the way, there's a Supreme Court case that is pending on this very issue. And I wonder if you could enlighten us on this issue, because I know you've been talking about it as well.
So this is a prime example of that emergency principle that I've referred to a couple of times, Izzy. So there are certain kinds of false statements that directly cause certain specific harm and may be restricted, may be punished, may be censored. One example is defamation, an intentionally false statement or recklessly false statement that injures somebody's reputation and does demonstrable harm. Another example is fraud, an intentionally false statement that is intended for somebody to rely on. The person does rely on it to their detriment, suffering adverse financial consequences. Another example is perjury, intentionally lying in a legal or judicial proceeding and interfering with the rule of law and the system of justice. But when we get beyond those specific, serious, direct kinds of harm caused by intentionally false statements, and we use this very loose, subjective concept of fake news or disinformation or misinformation, it is completely subjective. It is such a vague and overbroad term. One person's disinformation or fake news is somebody else's cherished truth. And I can give so many examples of that. One example, and this has to do also with hate speech and extremist speech, is Black Lives Matter advocacy. That has been attacked as not only hate speech against police officers and against white people, but it's also been attacked as misinformation. Powerful politicians have said that Black Lives Matter advocacy is really Marxism, and it's not really about racial justice, and therefore it's disinformation and should be punished as such. What we have to do in a free society is leave it to we individuals to make our own determinations about what information out there we think is reliable, what we think is misleading, what we think should be trusted or not, and is not, as the Supreme Court said in one of the cases you alluded to, Izzy, we don't need Orwell's Ministry of Truth in our country.
On this
I'd like
issue.
to tell, may I tell you about a lawsuit that the ACLU won last year about, there was an anti-disinformation law that was passed in Puerto Rico
Oh, yeah.
shortly after the pandemic went into effect. And there were anti-disinformation laws about COVID that were passed all over the world, but two of them in our country. Just a second, please.
Yep, absolutely. Please.
And in Puerto Rico, there were two such laws. The ACLU immediately brought a lawsuit challenging them under the First Amendment on behalf of two prominent, respected investigative journalists. And they said, no matter how hard you work, especially in a fast-breaking situation such as this health emergency and all of this information and debate about what the causes are and what the appropriate treatments and responses are, no matter how conscientious you are, you inevitably are going to make some mistakes. And to treat that as punishable disinformation is, first of all, it's unduly harsh and unfair to journalists, but even worse, it's going to have a chilling effect. What journalist is going to dare to publish something if they fear that they're going to be subject to this anti-disinformation law? And that means that not only are the journalists being stifled in their exercise of free speech, but we, the people, are deprived of the benefit of their coverage of this situation. When we won the lawsuit, the judge had very, very strong language in which he said, especially in a public emergency, such as a health emergency, it's especially important to not stifle the press and to, allow them the latitude that inevitably is going to result in some mistakes, but that's a lot better than too much suppression.
Speaking of suppression, and I know SPJ New England posted this question on the on the chat. Here's the question they ask: what are your thoughts on social media companies censoring speech on their platforms? Conservatives say their posts and tweets are being censored or their accounts are being suspended or deleted. These are also private companies. What are your thoughts? And I guess, Nadine, this is in the context of there are now several cases pending before the Supreme Court that sort of revolve around this issue of the rights and responsibilities of platforms. You have what we call the net choice cases. These are cases where states in Florida and Texas said that social media companies must carry speech. Some people say that's compelled speech. There's also the case of Murphy versus Missouri. This is the case involving the Biden administration and whether or not there was coercion between the government and social media companies of what they must take down. You were the president of ACLU in a very famous case called Reno versus ACLU. And in this case, the Supreme Court said, because the ACLU argued correctly, that when it comes to the internet, the government can't regulate what's going on in this marketplace. And by extension now, some people would argue that extends to the platforms on social media. Can you talk about, because I know you have also been vocal on this issue of whether or not governments, whether it's the state level or it's the federal government, can say to these private entities, you must do this or you cannot do this?
Yes, and these cases were just argued before the Supreme Court, and the consensus of observers seems to be that the majority of the Supreme Court are very sympathetic to the First Amendment free speech rights of the social media platforms themselves. Since they are private companies, they are not bound by the First Amendment. They have no obligation to protect free speech rights of any speakers or of any message. To the contrary, they have their own First Amendment rights to exercise editorial discretion and decide which speakers and which messages should be permitted and which should not. That argument seemed to be, that's the one that I support, and it's much more importantly seems to be supported by the majority of the Supreme Court. In fairness, let me state what the other perspective is, which several justices seem attracted to, and that is to treat these powerful social media platforms essentially as common carriers, similar to the landline telephones or the telegraph companies in the last century, that they are such important communications infrastructure that they should have to follow non-discriminatory practices and policies that allow equal access to every single speaker, regardless of who they are and regardless of what their message is. I think that's a losing argument, but you know, several justices will support it. Beyond the content moderation cases, Izzy, you referred to the Murthy case, and that has not yet been argued before the Supreme Court. It's coming up in a couple of weeks. That presents the issue, as you rightly said, when government officials not only encourage social media platforms to take down certain messages or to silence certain speakers, and government officials have a free speech right. One would say they even have a public responsibility to try to persuade various media companies to act in what the government officials consider to be the public interest. That's generally called jawboning, right? Or persuasion or encouragement. But as you rightly say, the Supreme Court has recognized that when the expression goes beyond encouragement and becomes coercion, government is in effect forcing the social media companies to take down certain messages or deplatform certain speakers. And by the way, all of the messages and speakers that we're talking about are completely constitutionally protected. Government would not have the power under the First Amendment to directly censor any of the so-called disinformation at issue, which has related to COVID and to elections. So the argument is that government should not be allowed indirectly by coercing a private sector company to do what it could not directly do through censoring itself. And this is a very fact-specific issue. Did the government's actions, in fact, go beyond persuasion into the realm of coercion?
And I guess in the Murthy case, this involves academics, this involves scientists, but I've certainly also seen this, and I think reporters should, at least when they're covering these issues, understand the big picture. And that is, you know, when you're talking about deplatforming or forcing people on these platforms, this idea of what is the speech that is at stake, it goes back to what you were saying, right? That this is, at the end of the day, the government regulating content, what is being said. And so therefore, what should reporters know when they're covering these issues? I see it, for example, when it comes to states passing laws that regulate when teenagers can get on social media. You know, these are age verification laws that say, look, if you are a 15-year-old and you want to get an account on Facebook, you should have your parent okay and give you permission. Certainly these cases have now gone to at the district court level, and across the board, the courts have said, look, this is government trying to regulate what, you know, the speech of teenagers, the speech of children. And sometimes people think, well, there should be a balancing test. And every time somebody says there should be a balancing test, I shudder, because on the other side, I'm concerned who would be doing the balancing test. But can you explain why it is that these courts are saying the rights of the teenager to speak are just as important as the right of adults to be able to be on these platforms and say what they want to say?
Right. Before I comment on that, Izzy, I'd like to make one more point about the Murthy case, which is I've been very surprised at the extent to which political liberals are very skeptical of the arguments in that case. And I think I want to urge again that people should not look only at who the parties are in a particular case, but understand that the principles apply to everybody. So in this particular case, it happened to be Biden administration officials that were engaging in the allegedly coercive conduct. But make no mistake about it, if Donald Trump or anybody else is elected president, they would definitely be trying to exercise the same type of coercive power. So please, try to be neutral in your understanding and explanation of these principles. With respect to young people, the First Amendment does not contain an age limitation. There are certain provisions in the Constitution, how old you have to be to run for president, Congress, and so forth, that are age specific. But with respect to First Amendment and other freedoms, the Supreme Court has said these rights do not magically spring into being only when somebody attains the state-defined age of majority. And the Supreme Court has regularly upheld the free speech rights of minors in public schools and outside of public schools, going all the way back to one of its earliest free speech cases ever, before the court really was upholding the First Amendment at all. One of its earliest cases in 1943, West Virginia Board of Education versus Barnett, upheld the free speech and freedom of conscience rights of school students, who were members of the Jehovah's Witnesses, who refused to salute the American flag and therefore violated statutes that had been passed all around the country. This was during World War II, and in the spirit of patriotism, it was thought that it was undermining the war effort for these kids to have a conscientious objection to saluting flag. And the Supreme Court, in very strong language, upheld the right to be free from compelled speech, upheld freedom of thought and belief, and it didn't even advert to the fact that these were young people or students. It just took it for granted that they were folded in within the First Amendment. Beyond that is the current kinds of laws that are singling out or purporting to single out minors, the age verification laws, suffer this very same defect that we've seen in other laws that purport to single out minors, including the internet censorship case you referred to earlier, Reno versus ACLU, because as a practical matter, adults are subject to the same requirements, right? The age verification, how are you going to prove that you're an adult? You have to submit the documents, and that violates your privacy, which can very well have a chilling or deterrent impact on your freedom of speech.
Does it surprise you, because Reno versus ACLU, you were there when this case came before the Supreme Court? This was at the dawn of the internet, right? This dealt with Section 230 of the Communications Decency Act. Does it surprise you that age verification is up against? Because age verification was an issue that the Supreme Court dealt in Reno. So now it's back up, but it's the states that are trying to regulate. And what they're arguing is, well, we're not regulating speech, we're regulating behavior. You've seen this now, a span of 23, 24 years. What surprises you about this argument sort of creeping up again? And for reporters covering this issue at the local level, what should they know about this issue?
Well, the principal founder of the ACLU, Roger Baldwin, once said, "No fight for civil liberties ever stays won." The same issues keep recurring in every generation, and I don't deplore that. I think it's completely consistent with free speech and open inquiry that we should re-examine even the most tried and true principles. But I think that it is important to know that there is an enormous amount of precedent that that these laws are flying in the face of. There have been so many efforts to shield minors from expression that is seen as somehow being harmful to them, including laws that restricted library books or that restricted bookstores in what they could sell. supposedly to protect minors. And over and over and over again, the Supreme Court has said, number one, minors have their own First Amendment rights. Number two, the expression may well be beneficial to minors, far from being harmful to them. Number three, even assuming for the sake of our argument that this material is somehow harmful to minors, we still cannot justify depriving adults of access to the material as the price to pay for protecting minors. Number four, parents have a constitutional right to shape the education, upbringing, and values of their own children. So these laws are not only violating the free speech rights of minors, the free speech rights of adults, they're also violating parents' rights to make determinations about what their own children should be exposed to and not exposed to.
So we've covered the right of reporters when it comes to protests and what they should know about protests. Certainly now, because it's in the news, covering social media cases and what should do, whether it's, compelled speech from, conservative states or liberal states. Just on the issue of the responsibilities of journalists, I get in trouble as a scholar and as a First Amendment attorney, Nadine, because I look at cases like 303 Creative versus Alonis, or I look at cases like Kennedy versus Bremerton. And these are cases that, for me, these are about expanding the rights of the First Amendment, right? In Kennedy, it involved a coach who was praying at the 50-yard line after a football game. Everyone thought that was a prayer case or it was a free speech case. I saw it as a public employee speech rights. And so therefore I want public employees to have greater rights. When you look at headlines and reporters are covering matters of the First Amendment, you mentioned briefly that sometimes reporters don't understand sort of the nuances of the First Amendment. How should reporters be covering these issues when it comes to the First Amendment? Because I could hear it from their voice saying, well, gosh, but if I defend the First Amendment, I'm gonna take a hit in public or in the newsroom or with my friends. It's a tough job to do that, right?
It's a tough job, but it is so essential, and ultimately everybody benefits. I sometimes refer to the golden rule of free speech. We cannot have freedom for the speech that we love unless we're also willing to defend freedom for the speech that we loathe. And I urge reporters to do what we lawyers do, and that is to look beyond the particular individuals involved in a certain case, to look beyond the particular message involved in a certain case, and look at the underlying principle and be aware that that same principle is going to come to the defense of exactly the opposite message or a speaker with exactly the opposite perspective. So if you don't like what the football coach was saying, or you don't like what the website designer was, refusing to be compelled to create, think of a message that you would support, or think of a message that you would oppose being compelled to create. It's exactly the same principle. And I think reporters have a big educational responsibility, Izzy, to not sensationalize the results of a case by focusing unduly on whose axe was gored in a particular situation, but helping us to understand the larger ramifications and other factual contexts where that principle is going to benefit very different speakers and ideas.
To that end, SPJ New England posts this question for you, Nadine. You mentioned that both sides of the political spectrum think speech should be more limited. How can we get citizens excited about free speech again? And this is, again, you just mentioned right now that reporters should see themselves, like you see yourself, as educators of the First Amendment, because they benefit from the rights and responsibilities of the First Amendment. So how can we get citizens as reporters to know why this is so important?
I have a couple ideas, Izzy. One of them is to remind people of what is going on in the rest of the world. We know that there are countries where journalists are being murdered, where they're being arrested, where people are being arrested, not to mention murdered, as in Russia, simply for dissenting from government policies. My friends who are human rights activists in other countries sometimes say, you know, you Americans, you take free speech for granted. And so I think it's really important for people to understand how different, you know, what a luxury we have in things that other people in other countries are sacrificing their lives for, risking their lives to be able to critique government officials, to be able to dissent from government policies, to be able to engage in public protests. These are such luxuries that throughout human history, people have fought for and died for, and very few of us have realized. I think another kind of perspective is to look at not that ancient history in this country, because the First Amendment existed for most of its history only in theory. It wasn't enforced in reality. And until the second half of the 20th century, government was consistently punishing people for engaging in expression that is completely constitutionally protected. But the Constitution isn't self-enforcing. I mean, the fact that Eugene Debs, who was the leader of the Socialist Party, got more votes for president than any recent third-party candidate, but he was imprisoned for making the most tepid statements about disagreeing with our policies in World War I. He received a 20-year prison sentence for that. Congress completely banned any petitions against slavery during the 19th century, leading up to the Civil War. It was a crime to petition your government for redress of grievances, the denial of the most basic human rights. And, you know, civil rights demonstrators in the early 20th century, middle 20th century, were repeatedly arrested. Why did Martin Luther King write his famous letter from a Birmingham jail? People know he was in jail. What was he in jail for? For
Right.
exercising what we now consider to be the most fundamental right of peaceful protest. So we should not take these rights for granted.
My dear friend, Catherine Foxhall, who is my SPJ colleague, she is a member of the SPJ DC chapter. Her, along with Frank Lamonte, who's now Deputy General Counsel at CNN, they've been on the leading front of making this argument, Nadine, that when local governments or national governments, when they restrict the rights of journalists to talk to subject matter experts, when, you know, public information officers stand in the gap of not being, you know, journalists not being able to talk to government officials, they say, look, that's a violation of the First Amendment. Can you talk broadly, because I know when you were at the ACLU, and you've mentioned this when I've heard you talk, that access to the work of government is vital to the work of journalists trying to defend democracy. In this year, I could see that a lot of the reporters are going to run into a wall, whether they're trying to access government documents, trying to access the courthouse, or trying to access subject matter experts when it comes to talking to officials. How important is it for journalists to stay just dogged in their pursuit of making sure that the work of the government is brought into the open?
It's so important. And the First Amendment itself, it contains an implicit protection for access to basic information about our government that has been concretized in freedom of information laws at the federal level and at the state level all over the country. But again, as with the Constitution itself, it's one thing to have the law and another thing for it to be enforced. And the ACLU has a whole staff of lawyers that do nothing but try to enforce Freedom of Information Act requests on behalf of journalists. It's critically, we can't possibly monitor what the government is doing. We can't possibly criticize or reform what the government is doing unless we know what it is doing. And that's such an important role that the press plays. And again, in collaboration with lawyers and with organizations such as yours.
So as we start wrapping up, I've learned so much from you just right now in talking about the importance of the First Amendment to reporters. I do hear this a lot from my friends in the news business. I wonder if we could just have this conversation about why they shouldn't be saying this. But I'll hear, for example, my friends say, well, you know, the Supreme Court says that you can't yell fire in the theater. And I tell my students, if you ever make that argument, I will pull back your A. You cannot make that argument after you leave my class. And students go, well, why not? You know, that's what the Supreme Court said. And then I try to explain to them the case that arose and why that argument doesn't make sense in the 21st century. Can we have that conversation as to, because, you know, I try to pound my head when I hear that, but it seems like that argument stays still, even in the press.
It's true. It's such a cliche, and it's a little bit like that other dread phrase you referred to, is the balancing test. Because, you know, once people invoke these inherently subjective terms, it becomes an excuse for eliminating freedom of speech anytime that there is a fear that there might be some danger or there might be some countervailing benefit from suppressing speech. So first of all, let's get the quote right, because that is, and you paraphrase it the way everybody paraphrases it, but what Holmes actually referred to was, you may not falsely shout fire in a theater and cause a panic. And those qualifications are really important. They go to the emergency principle. If the theater is on fire, you want people to shout, right? Because that will be life-saving. But if it's false and it causes a panic, then the speech is directly causing harm. And consistent with the emergency principle, it can be restricted. But this is not to be trotted out every time there's a statement that people disagree with, which is when that line is typically used. Also, the factual situation in that particular case is really lamentable. We're talking about some socialists who were publishing anti-war pamphlets that were critical of government policies. There's no way that they were causing any direct harm to anybody. They were simply criticizing government policy. The right of we the people to dissent is the most important right in a freedom of speech in a democratic republic.
They were throwing flyers outside the window to the streets. You know, they were individuals who probably were just, you know, trying to, you know, do something right in the public policy.
They were trying to affect public policy, which is their
Right.
right as citizens in a democracy.
Right. And as I remind my students and I remind my friends in the press, you know, Oliver Wendell Holmes, whose, you know, biography I have back there, he changed his mind, and he changed his mind 6 months later. And then he articulated in a dissent this idea that, you know, the marketplace of ideas should be defended to its rigor, right? That we let the truth and falsehood have its way, and we believe that the truth will prevail. So certainly, you know, to help journalists understand that what's at stake, both to defend their rights as a member of the press, but to defend the rights of speech of all, That seems to me, going back to the headline of the New York Times, is the media ready? And, you do this, you speak at over 200 events a year, you talk to people all over. What are the things that concern you in 2024? And what are the things that excite you in 2024?
I am excited about the great degree of public interest in politics, including the great degree of interest on campuses. I don't take that at all for granted, Izzy, because until quite recently, there were a number of decades where college students were pretty apathetic about politics. I came of age during the late 60s and early 70s, where we had campus activism against the Vietnam War and for civil rights. But after that, students became quite passive. So I'm very happy that now we have students who are deeply engaged, not only in partisan politics, but also racial issues and gender and environment and immigration. And that's really wonderful. And I think for our society in general, the fact that people are interested and engaged in political issues is very important. What troubles me is the extent to which we have, these will be familiar complaints. Cancel culture, we adverted to that earlier, that no matter how strong the free speech law is, we're never going to really have freedom of speech. You quoted George Orwell making this point, unless we also have a free speech culture where people are not intimidated from expressing their point of view for fear that they're going to be subject to some kind of social stigma, some kind of social punishment. And in fact, surveys indicate that throughout our society, including on university campuses, the greatest impediment to free speech is not that people fear government is going to punish them, but rather they fear peer pressure. They fear social ostracization or shaming. And yes, of course, you have the right to criticize somebody whose views you disagree with. But I hope we could be a little bit more muted and not so overly harsh, not so disproportionately punitive, that people fear to discuss whole important topics altogether.
I have a few more minutes. So since you just brought it up, I do want to at least have you talk about this, because you made this a point in your book, and you differentiate between two different concepts. You said, you have this idea that the right to think is the beginning of freedom and speech is the beginning of thought. And then you combine that with philosophy, with Rene Descartes, who said, I think, therefore I am. And what you do is you combine those two ideas and you say, I speak, therefore I think, therefore I am. And you contrast that with George Orwell. You just mentioned this idea of newspeak language, right?
Yeah.
Reducing people's vocabulary. Journalists, they should do the former and not the latter, correct?
Yeah. And that quote was not from me. That eloquent phrase came from Justice Anthony Kennedy on the Supreme Court. And, it is, and the Supreme Court has said in a case that involved a phrase that was extremely taboo at the time, now is quite common, the word fuck. But at the time in the early 70s, that was considered to be such a terrible word that the Supreme Court Chief Justice asked the ACLU lawyer who was arguing in the case not to say the word. But when the Supreme Court rejected the argument that that word could be eliminated without changing the message. In other words, a paraphrase would not be the same. Every time you stop somebody from choosing the exact words that they want to use to convey their particular message, including the degree of emotion that they associate with their idea, with their expression, that is a form of censorship. You cannot banish a word without banishing ideas. And the whole point of the newspeak language in Orwell's 1984 was to eliminate words, to eliminate the ideas that go with them. You know, there was a frightening example I saw of this, Izzy, in that actually existing today. Somebody who had escaped from North Korea was talking about the words that she did not know in her Korean language until her family escaped. That she said they had no word for love. She never heard her father say that he loved her mother. She never heard either of her parents say that they loved the children. Obviously, there were no words for rights or freedom, or and so it really is quite demonstrable that we need the vocabulary in order to purvey the ideas.
Nadine Strossen, this has been an amazing conversation. I'm a huge fan of Ezra Klein in his podcast. So therefore, I'm going to take, they say that you can take ideas, just, you won't get accused of copyright. So I'm going to take his idea about what do you recommend for people to read? I'm going to recommend that people buy your book, Free Speech, What Everyone Needs to Know. This book should be on the desk of all reporters. And by the way, Nadine, for anybody who works in the newsroom, the F word is said quite frequently in many different contexts. There's the book right there, Free Speech, What Everyone Needs to Know. Thank you very much, New England, SPJ New England, for saying, hold up the cover. I have it. I really did read the book. I promise you, I loved it. But what are other books that the people should be reading, that journalists should be reading, so that when they go into the 2024 election, they feel empowered, they know that they are doing more than just doing news gathering, that they are defenders of the First Amendment, and that they're doing important work that prevails with democracy thriving? What would you recommend?
Wow, there's so many, but let me confine myself to two for now. One was a book written by Jakob Mchangama, Mchangama. He is my senior fellow at FIRE. He's a Danish human rights and free speech activist, and he wrote a book that came out a couple of years ago called Free Speech, A Global History from Socrates to Social Media. By the way, he's also done a series of podcasts on FIRE's website, so you can essentially listen to his podcast version of the book. And the reason why I think that is so great, Izzy, is because it really shows that throughout human history, around the world, in every country, every form of political system, there has been an eternal striving on the part of human beings toward freedom of expression and eternal efforts to suppress. And I think, with that historical context, again, it shows how special our situation is in the United States, and how we should cherish it and prize it and exercise it and protect it, rather than being skeptical about it or rejecting it, as too often happens. The other book I would recommend is by Anthony Lewis, a great journalist. He wasn't a lawyer, although he took a few courses at Harvard Law School. For a long time, he was a New York Times columnist, and his book was called Make No Law. And it is a detailed study of one of the most important Supreme Court cases ever, New York First Amendment cases ever, New York Times versus Sullivan in 1964. And what that book does is to give you the background and to understand how critical not only the Sullivan case, but all of the landmark First Amendment cases in the middle of the 20th century all arose out of the civil rights movement. And without this robust protection of free speech, the press would have been shackled. That was the point. There was a campaign by Alabama and other southern states bringing multiple defamation lawsuits against the New York Times and other national media outlets, and also bringing defamation lawsuits against Martin Luther King and civil rights movement in order to stifle both the demonstrators themselves and the national press, whose coverage was absolutely essential to the success of the movement and to bringing about the 1964 Civil Rights Act. So I think that is such a wonderful salute to the special role that the First Amendment plays in advancing civil rights and human rights and racial and equal justice, and the special role and responsibility that journalists play in fostering free speech and therefore all of our other rights.
Well, I've linked to a YouTube channel of The Fire, which has a talk on the history of free speech, and your book mentions it. Highly recommend you watch this YouTube video. And then I've put a link to Make No Law. Again, everyone should read the case involving Sullivan. Nadine, thank you so much for spending your Monday with us. For those who are watching from the comforts of your laptop, I also have to remind you that SPJ National has the Legal Defense Fund, and we are there to help journalists who are facing litigation problems when it comes to doing their work of the First Amendment. So don't forget, we are there to be on your side as well. And then SPJ New England, they've got a region conference coming up. Make sure and get involved at the local level, because what we have is something so precious that we need to fight for it. Nadine Strossen, thank you so much for spending your Monday evening with us.
Oh, thank you so much, Izzy, and to everybody else who's been in attendance. And thank you for your great work.
All right. Take care. Have a great time, everybody. We'll see you next time.